I'd like to call this session of the Will County Board of Adjustments to order. Thursday, January 11th, 2024. First item of business, approval of the minutes. Entertain a motion.
I'll move that we approve the minutes as presented.
Have a motion, a second, all in favor?
Mr. Chairman, I have a couple small
ahead.
corrections, if I may.
Go ahead.
The second line of the second paragraph on the first page, where it says specific requirements of the permit of the variance from the, or a variance from the requirements for a permit. I think requirement to obtain a permit is a clearer way of stating what the intention was. And
I'm sorry, can you say that again? I don't.
rather than from the requirements for a permit, from the requirement to obtain a permit. And then on the first paragraph of page 4, the 1, 2, 3, 4, fifth line from the bottom, Mr. Uhas asked if the base of the wall was where it says wall came to, it's where the water came to. And with those two corrections, I'm happy with the minutes.
Considering those two corrections, do I have a motion to approve the minutes?
So made.
It'd be,
We have a
to-
motion.
Mr. Chairman, it would be
Yes,
a
sir.
motion to approve the minutes as amended.
As amended, yes.
As amended. And a second. All in favor?
All right?
Motion carries. No old business to discuss. We have an application for an variance. Mr. Eads, if you'll introduce that, please.
Yes, sir. As you indicated, Mr. Chairman, this next item is an application for a variance that was filed by Mr. and Ms. Thomas and Mary Markle, who were under contract to purchase the property located at 621 East Beach Drive. That property is the subject property for the variance. As I read their application, but I'll let them speak for themselves as well as staff, it is to encroach either 4 feet into the front setback or 2 feet into the front setback and 1 foot on each side. This is a quasi-judicial evidentiary hearing, which means we'll conduct it somewhat like you would a courtroom hearing, and we'll follow the North Carolina Rules of Evidence, but not as strictly as we would in a courtroom. All witnesses must be sworn in before they testify and will be subject to cross-examination and to questions from the board. As a quasi-judicial hearing, the applicants are entitled to a fair and impartial decision-making body, which essentially means you have to base your vote solely on the competent, substantial material evidence that we hear during this hearing, not something you may have heard outside of the hearing. So I need to ask a few questions of the board as a whole to ensure you can be fair and impartial. So the first question is, does anyone have a financial interest in the subject matter of this variance application? Right? Does anyone have a close business or family type relationship with the applicants, the Markles? Okay. Have any of you made a site visit to this site solely for the purposes of assessing this variance application? Have any of you had any conversations outside the course of this hearing with a staff member about the subject matter of this variance application? Same question with respect to the applicants, Thomas and Mary Markle. Have any of you talked to the Markles or one of the Markles about this application? Right. Can you think of any reason that would prevent you from being fair and impartial and preclude you from voting solely on the competent, material, and substantial evidence you hear today? The order of proceedings after, we'll first swear everyone in, then we will hear from staff, and I believe Mr. Brady Golden, Town Planner, is going to introduce the item on behalf of staff. Then we will hear from the applicants, and then we will hear from any other party who has standing, who wishes to speak on the matter. The applicants and the variance requests have the burden of proof. They must prove through competent material and substantial evidence that they meet the 4 criteria located on pages 6 and 7, which is the bottom of page 6 and top of 7 of the staff report, lays out the 4 criteria. In order to obtain a variance, there must be a vote of 4/5 or more in favor of granting the variance. So unless, Mr. Chairman, you have any questions of me before we get started, I would ask all those who intend to provide testimony to be sworn in by Madam Clerk.
No, I don't.
Do you solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
And just for those who might not have been through one of these procedures before, there will be a transcript or at least minutes of this hearing. So when you take the podium, I would ask you to identify yourself and speak at a tempo that will allow Madam Clerk to get the minutes down, and let's not talk over each other. So, Mr. Golden, go ahead.
All right, my name is Brady Golden. I'm the town planner, Planner 1. What we're here to evaluate today is a Board of Adjustments variance application for modifications to the setbacks at 621 East Beach Drive. Just to go over the variance standards, North Carolina's General Statute 160D sets forth the verbiage on how we look at variance requests. It reads, when unnecessary hardships would result from carrying out the strict letter of a zoning regulation, the Board of Adjustment shall vary any of the provisions of the zoning regulations upon a showing of all of the following. Number 1 is an unnecessary hardship would result from the strict application of the regulation. It's not necessary to demonstrate that. In the absence of the variance, no reasonable use can be made of the property. Number 2, the hardship results from conditions that are particular to the property, such as location, size, and topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. Number 3, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. And number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secure and substantial justice is achieved. A variance also requires a concurring vote of 4/5 from the board in the affirmative. Some background on this, as Mr. Eads stated earlier, the applicant is requesting a variance from the front and or side yard setback requirements to construct a single-family residence. The subject property is located at 621 East Beach Drive, parcel ID 235PE017. Property is zoned R7 and is subject to a 15-foot setback in the front and 8-foot setbacks on the side. The applicant is requesting to encroach 4 feet into the front yard setback, or alternatively, 2 feet into the front yard setback and 1 foot into each side yard setback. Here is a map of the area, just south of East Beach Drive, indicated by the red dot in the middle. Also, here's a zoning map that shows that the zoning district is the same for the surrounding area as R7 residential. Here is a survey of the property that shows the area, the built-upon area. And this also shows the proposal for 15 feet in the front and 8 feet on the side. So this is a standard setback requirements. Once again, here are the variance standards. I'm happy to answer any questions going forward.
If I may, Mr. Chairman, as I look at the agenda packet, it looks like pages 6 and 7 are the staff memo, and 8 through 38 are the applicant's variance application and other submissions related to that application. Would you like to introduce that into evidence
Yes.
as Exhibit A? Is the applicant, are you Ms. Markle? Do you have any objections to his staff memo and your application coming into evidence? Thank you. Mr. Chairman, I would recommend we accept pages 6 through 38 into evidence as Exhibit A without objections.
Very good, no objection.
All right. Are there any questions of Mr. Golden?
Yes, I do. On the lot map, you indicated on the red dot, that lot that's in question. Are they the same size? Looking east to the rest of the lots, are they all the same size?
They are a standard 7,500 square foot,
So this is a standard lot.
7 district, yes, sir.
Is the lot to the west looks like a double lot. Is that, do you know if that's been merged? Or would that be able to be further re-subdivided and used as 2 lots in the future?
So it more than likely has been combined at one point, and it could be, the original lot lines could be reestablished at some point, as long as all those standards are met for the zoning district of R7.
But as far as you know, the zoning requirements as far as lot width and area are the same now as they were at the time that this property was originally subdivided?
Correct.
Now, what's changed and what causes this to be an issue is the line of vegetation, is that right?
Correct.
Which is fluid. The town's setbacks are concrete, they don't change.
Correct.
The line of vegetation has changed over the years, and at this point in time, is such that it only leaves X number of square feet for a building envelope, which is less than the covenants allows. That line of vegetation a year from now could change. It could be different inland, could be different offshore. So it just so happens at this day and time, it's at a point where it causes the lot to be unbuildable without a variance. And obviously, you can't get a variance from CAMA for the vegetation setback. Is that right?
Courtney, would you like to speak to that?
We don't have a CAMA officer here?
We do.
Are you sworn in?
Courtney Milliron, I'm the floodplain administrator and the CAMA LPO for the town of Oak Island. They can apply for a variance through the Coastal Resources Commission for an exception to the 60-foot setback, but it's going to be up to the CRC as to whether or not they approve that. But they do have to exhaust all of their options at the local level before they can seek that variance.
And in your opinion, what's the probability of getting a variance from CAMA in a situation like this?
I can't speak to that. I'm really not sure on that.
It being the state, I'd take a guess. Slim to none. Any other questions?
I do have one. It's kind of out of the clear blue. That lot to the immediate west was like maybe a double lot. If the property owner of the lot in question were to ask that property owner, could they encroach on their property? Would that be a town issue or just an issue between the two parties?
So at that point, if they encroached on the neighboring property, that would be not cohesive with our regulations. So we couldn't sign off on a development permit that shows encroachment into a neighboring property.
Even though the neighboring properties started, could that neighboring property sell a block of that?
So the problem you run into when you try to sell off portions of a lot is there are dimensional standards for lot width that you have to meet. And these lots are right at that limit. So if they couldn't give a portion over.
No, we're not talking about encroaching on the neighboring property. We're talking about encroaching on the setback of the existing property. So we're not leaving the property.
No, I was just curious about that.
Do you, if, would there be a problem meeting the parking requirements more or less? Would there be more or less of a problem meeting parking requirements with a 2-foot extension into the front yard versus a 4-foot extension into the front yard?
Without a site plan, I can't really answer that to see how, the design would show.
Okay.
I follow your point, Steve, and that thought occurred to me. The 4-foot is pushing the parking area further into the traffic, obviously, opposed to the
I mean,
2-foot.
presumably there'd be parking underneath, but I don't,
Still, you're pushing further that way.
Any other questions?
yeah, I guess one last question. Over the years, has the front setback zoning requirement for this zone changed at all, to your knowledge, or to the knowledge of anyone else in the room?
There is a provision for these beachfront lots that the standard front setback is 25 feet. But since these are beachfront lots, there's, like I said, a provision that changes that to 15 feet. So I'm not sure when that was put into the ordinance, but it's been that way in the little over a year that I've been here.
Does Mr. Edwards is here, would he have knowledge of that?
He was sworn in.
Well, we can fix that.
You've been subpoenaed.
Swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
This lot here could ever be subdivided in the future? Possible, depends on how close this house is built.
Steve Edwards, Development Services Building Code Director. Yes, the setbacks have been changed over the years. It was approximately 2004, 5 maybe, when we changed the front yard setback from 25 feet to 15 feet to accommodate the shortening of the building envelopes that were being created by erosion.
Okay, but it was never less than it is now.
There are, I can't speak to that, but there are properties out there that are sitting closer than 15 feet to the road.
There are.
There are. So at one time, evidently, there were some less setbacks or errors made.
Thank you. I can't imagine errors. It must have been.
Well, Steve, hold on. Because Ms. Markle has the opportunity to cross-examine all witnesses, so are there any more questions for Mr. Golden?
I had one question for Steve. If we grant this, that means the setback from the right-of-way is 13 feet.
That appears to be one of the options, if they
Yeah,
want the 2
yeah.
foot and 1
So
foot on sides.
any large vehicle would in effect be parking partially in the right-of-way, correct?
Well, there are exceptions to the CAMA setbacks where parking facilities can be within that 60-foot area. So if, and we have seen this on site plans where they have pushed parking out in front of the principal structure, which would be the house footprint. So they could actually create parking a little seaward of the principal structure as long as they don't encroach into beyond the first line of vegetation or into the frontal dune system.
Thank you. I wasn't aware of that.
Okay.
Before you go, sorry, just wanted to clarify.
Ma'am, could you go to the microphone and identify yourself? Thank you so much.
Hi, I'm Mary Markle, and just wanted to clarify with it being 15 feet from the right-of-way, I just don't want people picturing the house like right on the road. I mean, it's from the lot line, which as you can see on the, I just want to clarify that, you know, the road doesn't start right where our lot line is, correct?
Correct. The edge of the pavement is not the property line. The property line sits approximately, I'd say 15 feet off of the edge of the pavement.
Questions for me?
Any other questions?
Ms. Markle, do you have any questions of Mr. Golden?
No, I do not.
And you're finished, or finished? You have no further questions for Mr. Edwards?
Correct.
Okay. All right.
Thank you.
Ms. Markle, we'll hear from you, or whoever, whatever evidence you want to put on as the applicant.
Okay. Well, hi, first, thank you so much for meeting, and I apologize for the baby. This is Poppy. I don't think she needs to be sworn in, but she's here. So just wanted to thank you, and hopefully she's not too much of a distraction, but childcare can be challenging. So I'm Mary Markle. My husband, Tom Markle, can't be with us because he's with our 3 other kids at home right now. But we have been in the Charlotte area for 10 years. We're both lawyers in the area. And then we are now looking to have a family beach house with our 4 kids. We just love the Carolinas, where my husband's been here since his early 20s. He was stationed in Fort Bragg. So we just really love the area and appreciate you taking the time to meet with us. As it's been explained, the problem that we're running into is that our lot has setbacks that allow for a building envelope of 884 feet, which would be fine for us. However, there's a restrictive covenant back from, I think, 1968 that requires all main floors to be 1,000 square feet. So that's where we run into an issue. We can't comply with both the setbacks and that restrictive covenant. So that's where we're looking for relief. So the restrictive covenant was put in place in 1968. Our first option was looking, we consulted our attorneys to see if that restrictive covenant was still enforceable, and unfortunately it is. So that basically means that if we were to start building, that any neighbor could stop the process, and rightfully so, because that's the way the law is written. It was reiterated in the chain of title in 1996, and then the vesting deed to the current owner as well. So because of that, there was a case in 2022, the Auger case at the North Carolina Supreme Court, almost gave us relief here, because if it hadn't been referenced in the chain of title, we'd possibly be in the clear. But unfortunately, that option didn't work. So this restrictive covenant was written to apply to 30 lots, 15 of which are oceanfront. Most of them you can see on the screen right there. And of those 15 oceanfront lots that this applies to, all of them have either been recombined or built on, other than our lot in question. So this is the only lot left that does not have a building on it yet, and that has the restrictive covenant. So that's where we run into the issue. So I'm just going to try and quickly run us through the 4 criteria. The The unnecessary hardship, which I've started to get into, is just the basic fact that the lot is non-buildable. I know the statute doesn't require no use to be made of the lot without the variance, but that actually is the case here. Without a variance, there is no option for building because you can't comply with both the current setbacks as they exist and the restrictive covenant. Then the next one, with it being unique to the property, that's where we get back to that this applies to 30 lots, 15 of which are oceanfront. Now they've been recombined, so this is the only one that is vacant at the moment that this applies to. And the reason that the others, so every house on that screen complies with the 1,000 square foot requirement. The majority of them were built in the 60s. There's one as recent as the 80s, but they were all built prior to the more restrictive CAMA regulations that went into impact last year with the CRC Beach Management Program. So all the other lots were able to easily comply, and we would easily comply as well if it weren't for the new first line of vegetation. So because now you have to be 60 feet back from the first line of stable natural vegetation, ours would be, as you can tell, be much closer to the road. That leads us to, that it's not an action that's caused by us. This is caused by the combination of the restrictive covenant that's in place from the 60s, but really what's really causing it is the new CAMA regulations that went into effect last year. So because of that, that is the cause. And so while the new regulations obviously are a minor inconvenience for us, we completely understand and respect the need for the heightened requirements on the oceanfront side, which transitions to the last point, with it being the spirit and intent. We're not asking to encroach on the front setback because we completely understand. We know that we need that 60 foot from the first stable line of vegetation. So what we're basically looking to do is find the least intrusive way. I know it's been tossed around 4 feet versus 1 foot on the sides. I mean, our preference, we want our house to look exactly like everybody else in the neighborhood. We're not trying to make it like, whoa, that house looks like it's right on the road. That's not our goal here. We're trying to get the smallest accommodation necessary in order to comply. So if asked, our preference would be just the simple 2 feet in the front and 1 foot on each side, just because that'll make it look the most similar to the other houses. And anyone walking by wouldn't even know there's a variance on the lot, which is our goal. We don't have any intent of building right up to our lot line or desire to do that. So this is just what we found to be the least intrusive way to put the property to its highest and best use with the minimum amount of relief necessary. At this point, I can take any questions.
Yeah, I do. When you purchased the lot, were these restrictions already in place?
So we are under contract. We close at the end of the month. And so they've been in place since 1968, which and that's one of the law says that there's no hindrance to getting a variance based on the fact that you purchase a lot with the knowledge of having having any sort of need for a variance on the property. So even though we are aware of it, thankfully the statute specifically calls out that doesn't make it not action caused by us by any means. So to answer,
You were aware of it?
so yes, we are aware.
Now, was the seller,
I'll just point out that that's an accurate statement of the law. It's not a self-created hardship under North Carolina law if you purchase a lot knowing that you'll need a variance. And you basically stand in the shoes of the seller if that person was eligible possibly for a variance, so would the purchaser. So.
Let me try to clarify this. In the packet, a lot of your information on your contract was included. You had a closing date that's already passed. Obviously, when you initially did the contract, you didn't know you needed a variance.
Correct, yes. So the original closing date was earlier this month. However, the second amendment to the contract.
Okay, let's back it up then. When you initially
Yes,
made
we
an
did not
offer,
know.
you didn't know.
Correct.
Did the seller know that he needed a variance at that time?
We do not know. According to the seller, no, they did not. But it was in his deed.
How'd you find it in your title search?
Yes, we found it in the title search. So that was not a great surprise for us. It sent us into a little bit of a panic, but we found it the day that our title search came back. I went through the documents and saw that, and then that's when we started consulting other attorneys just to see if there was an easier solution here that regulation might not, the restrictive covenant, see if it was still in effect. But yes, we did not know about it when we made our offer.
Okay, that's the point I wanted to make.
Thank you.
You didn't
We,
buy
yes.
it knowing you were gonna have to get a judgment. or get
Correct,
a
right, yeah, we
variance.
didn't put our deposit down with the thought, we thought that,
Okay.
we were fine building in an 800, almost 900 square foot footprint, that would have worked for our needs. So we were okay with that. It's just that we're not legally allowed to do that. But so yes, we did not know.
Okay, well, I just
Thank
wanted to
you.
make that clear, that you
Thank you.
didn't go into it knowing.
Right.
Mr. Eads,
Yes, sir.
we can attach conditions on a variance.
Reasonable conditions that are,
Is a reasonable condition conforming to the neighborhood as far as height limit, number of stories?
I mean, there's already a height limit.
Okay, number of stories.
Would the applicant consent to a number of stories limitation?
I mean, I think it depends what it is. We'd prefer the option to have 2 stories, because, but we have no intent of going to 3.
Now, just looking at your neighborhood, everybody else in that block is 1 story.
And that's, so, yeah, that's, I mean, we would definitely, given the 4 children, but that can't be taken into account personal situations, but having 4 children, we'd prefer to have rooms for them all if possible, but, yeah, so that's, and yeah, we're planning, our builder is Randy Moffett. I know he does a lot of properties in the area. So we had talked to, we've only looked at 2 stories, but of course, 1 story is better than no stories, so.
I'd only recommend adding that condition if the applicant consents.
Sorry, say again.
I would only recommend adding such a condition if the applicant consents. Agrees to it.
It seems to me that that's, even though, and I don't know for a fact, although I don't dispute, that all the houses on that block are already 1 story, it just doesn't seem to me to be practical at this point to build a 1-story house on the beach anymore. I mean, that's just, doesn't seem financially reasonable to do that.
You're right there. My point of that being there's a covenant on that neighborhood to keep the neighborhood to a certain size. That's 1,000 square foot on the lower level, and the other houses are 1 story on 1,000 foot. And they plan that neighborhood to keep it in that sense.
The restrictive covenant says the first floor has to be 1,000 square feet, specifically first floor.
First floor,
So it admits that there could be a second floor.
It proves, you know.
It doesn't ban a second story.
It does
It-
not
in
ban.
fact,
It's only first floor
Specifically
must be
ban it.
1,000 square feet. And ultimately, this is because CAMA moved the lines on everybody. These houses over here, they don't meet the setback requirement.
Just to, I don't think it shows, but there are a couple lots that are also subject to this that are 2 stories further west on the map. And just the restrictive covenant, they didn't want small houses. They wanted everybody to have at least 1,000 square feet. The law was trying to protect against smaller, I guess, shacks going up. They wanted to protect their value by making sure the neighborhood had at least 1,000 square feet.
well, I'm not against it, totally against it, obviously, but
Yeah,
just
you're
thinking to
looking
keep
for a way
it
out.
in step with the neighborhood. What we don't want is a 40 and a half foot high house there.
Who instigated the restricted covenants? Who has that authority?
So I don't know, I have to look up the owner, but the owner back in 1968 owned that entire block, and he subdivided it into those properties and sold it to be a development. He was calling it the Long Beach Development.
Who's in position to enforce that restricted covenant?
Anybody who is also subject to it. So any of those 15 oceanfront houses, and, well, there's not 15 because they've been recombined, but any neighbor can enforce it. And it's unfortunately specifically written into the restrictive covenant that they can get an injunction, and so that would stop construction and completely derail the entire construction process and leave the property unfinished.
So you think the neighborhood they'd want to enforce that covenant?
I mean, I could see personally, if it were me, and I wouldn't, not because I cared less about the size of the house, but just if there's anything that can stop a house going up, if you have a vacant lot next to you, I think I don't blame anybody for wanting to take those actions. You know, everybody really likes their peace and privacy, and it's always hard when a shovel goes to the ground, but, you know, that it is a vacant lot that was on the market and it actually, to go back to whether we knew about it, the lot was clearly marketed as buildable. And so we were completely caught off guard with this discovery.
Specifically, the lot across the street from it could enforce the covenant.
Dan and Irene Shannon were in on that.
Sorry?
Dan and Irene Shannon were in on that back in.
Steve makes a good point. The lot across the street would lose its view of the ocean
If he's in part of that restricted
with
covenant.
2 stories.
And they are,
They are.
yeah, because that's part of that, the second row houses were all part of that same subdivision and all.
I see.
Well, we're here on the variance application. And if as far as the number of stories and things like that, I mean, that's a secondary concern, pretty much outside the scope of this request. If there are restrictive covenants in the neighborhood, in addition to the town's code of ordinances, as to how high people can build and things like that, that's a private matter. What the Markles are asking for is a variance, and it wasn't clear to me from the application, but is it a either or, either 4 feet? And when I say front yard, I mean towards the street,
Correct, yes.
or 2 feet and 1 foot, 1 foot?
Correct. Either of those options would give us the building envelope that's required. As I said, our preference, because we feel that it'll be the least obvious to the naked eye, is the 2 foot into the front and 1 foot onto each side. Seems to be the least intrusive option. And just to go back to the 2-story, I mean, the big concern would be, I mean, I would be concerned, you know, property turns over eventually. I mean, we have every intent, this is our retirement plan. So, I mean, it won't be our problem, but down the road, if there is a 2-story restriction to the property, and, you know, if the nature of the neighborhood has changed, that's gonna significantly hurt property values. The same way this restrictive covenant is now coming back to, our seller could have an issue with his property value if we don't find a way to work with this. So that's, I mean, my main concern, I would say, if we put some sort of restriction on the lot as far as building, that would be unlike anybody else in the neighborhood. And down the road, if there are larger homes all around, that would really hurt the property value.
Yeah, the homes around it got some age on them, and there's nothing to stop the next door neighbor from selling his lot and somebody coming in, tearing it down and putting a 3-story, 12-bedroom house on it. At this, right now, I don't know what's gonna happen in a couple of years.
Correct.
I guess I do have a question not for the applicant, but for staff. If we can get someone to answer it, and that would be, is there any specific
I think it's a beach house for kids.
danger in reducing the side setback from 8 foot to 7 foot? I mean, generally, the 8-foot is helpful as far as getting equipment in along the sides, I would imagine, and generally for light and air.
So there is a 5-foot separation that has to be withheld if you do any closer to 5 foot on both sides. Within 10 feet, you need to have certain firewall installation or whatever. So yes, there is that point of getting back in the rear of the property if it was developed to encroach far into the 8-foot setback, then potentially you may have to go on the other property if there's room, or maybe there's not room at all. Yeah, that's the main concern, other than not being cohesive with the standards of the ordinance.
So there's some slight concern, but not an immediate specific danger that you can point to. Sure.
What's the height limit?
Depending on here, let me check it out. Depending on the
41
flood
feet.
hazards, depending on the flood hazard zone, it's either 35 or 41 feet. So if this is in the VE, let's see if that's noted on the survey. So yeah, it is in the VE hazard zone, so it is subject to a 41-foot maximum height restriction.
But they've got to go up 8 feet anyway on stilts, according to the restrictive covenants. So you can't get 3 stories in 41 feet unless you got a flat roof.
Yeah, you can. You look at all the 3-story houses on the oceanfront,
Yeah,
they're under 41 feet.
all right.
Chairman, the pen. Chairman.
Mr. Simmons, the pen is.
Yes.
Oh, sorry.
That's gonna be all
They're
over the
recording
microphone.
and
Thank you.
Any additional questions for staff?
Not at this time, thank you.
Okay, thank you.
Did anyone have any other questions for me?
Any other questions for the applicant?
Well, I would ask if we restrict the height to 35 feet against council, would you then automatically get out of this contract?
Oh, do we have an out? Yes, we could get out of this contract.
Would it be that objectionable? that
Oh,
you would-
no.
Okay,
I mean, I'd have to.
what I needed to know.
I have to talk to my husband. Obviously, I can't speak for both of us on how we would proceed, but I mean, as long as we can, I guess I would also have to make sure that we're not impacting property value and we're still paying the right price.
Second story.
So probably consult with our real estate agent to make sure we're not impacting the value too much if there was restrictions. I mean, of course, our preference would be not having that restriction.
I'm gonna backpedal out of that idea anyway, myself personally. After thinking about it, the houses on either side, if they burnt down or were tore down, there's nothing to stop them from, Going
Going
up.
up 3, putting a 3-story on stilts, yeah.
but be restricting them for future value.
Or even that empty lot next to it.
Yeah, that lot right next door.
Re-subdivide it and go straight up.
Yeah, I'm gonna back down out of that, idea.
I understand, Mr. Chairman, that the restrictive protective covenants are self-renewing. Can our council tell us what somebody would have to do to stop it from renewing? I mean, the man who did the development is probably not even alive anymore.
Well,
I would
wanna
think
keep
their
it-
attorney has looked into that.
I want to.
Yeah,
Oh,
they have
yes?
to record it.
And if someone buys in reliance, someone else buys pursuant to that restrictive covenant that's applicable
Yes,
to all those properties, they are entitled to rely and therefore have the standing to enforce that covenant. But whether they can or can't, the applicant's position is the covenant is binding.
Yes.
So we have to stay within the framework of they're seeking a variance to accommodate complying with that covenant by either a 4-foot encroachment on the street side, or 2 feet on the street side and 1 foot on the two sides of the house. I just, there's all kinds of tangential concerns we can talk about, but that's kind of beyond the scope of, we have a pretty distinct function here.
One quick thing I wanted to say about if we were still considering that restricting the stories is because I'm the applicant, which I'm allowed to be because we're under contract, but the seller would have to sign off on that. And since we haven't closed, I cannot imagine he would be too open to that. Because if our sale falls through, then he's now has that restriction and that might not be his preference. So it does complicate things if we go down that route.
Okay. Any other questions for the applicant? You got any questions for the board?
I do not. Thank you for your time.
You're welcome.
I believe someone else had signed up to speak. Did you, sir?
Other speaker? Okay. You'll state your name and address, please.
Thanks for having me. My name is Mike McIlvain. I'm at 620 East Beach Drive. I'm right across the street and to the side of where the Markles want to build.
Could you spell your last name? For me?
MCIL, V as in Victor, AIN. And my heart rate's really going because it takes, I'm not sure why, it just upsets me that they're dealing with this when that place has now had 3 realtors on that lot. I've been here since full-time, since 2020, but we bought our property in 2016. Since we've been full-time, and before that, there's been 3 different realtors selling that lot. The first one didn't have to state anything, but if you notice, if you look back, and I can't find it, the second realtor posted non-buildable, but we're hoping to change that. Obviously, I think they're talking about the renourishment thing that, we're hopefully getting funded in the next year or two. But again, that's, if that ever is going to happen, we don't know that. So my concern is for them and other people. I've actually talked to people looking at the lots. It's like, listen, I'm not the nosy guy. But I just want people informed that this is not a buildable lot right now, except for what they're trying to do. And they're not being told this to me, is just criminal. So basically, I'm sorry, I just had to get that off my chest because it just really upsets me. We love our property. We bought it and we had this great view. We've got the 2 lots right in front of us that are open. Matt owns the one that we're talking about that's vacant. He's the one that owns that house to the west of her. Neely, we become good friends, who's east of the property Markles want to buy. I just wanted to represent them since they couldn't be here, plus my own, just get the point across to where we're coming from. Where the setbacks, I have these notes and you guys have already talked about them, where the setbacks used to be 25 feet and they're put back to 15 feet. So we've already moved them back. And the ocean water is not going down, folks. I mean, we've got to do something about that first before we start moving lines around. But some of our issues, I've talked to my neighbor and she's got a letter here, sorry, go ahead.
If you're going to read.
I don't think I should. It's
Well,
from a second person, but if I'm allowed, I will.
It's hearsay,
Yeah,
and imagine if you were the applicant.
exactly.
And someone came in and read a
That's-
statement, then you wouldn't, that person's not going to be subject to cross-examination.
Fair enough.
I mean, well, do you have any objections to that coming in, Ms. Markle?
Yeah, I think that's not in line with what the board's supposed to consider.
Okay.
If you want to kind of give a gist of
I absolutely
of
can.
your understanding.
I
but-
will. My understanding is, first of all, and when Isaias hit us in 20, Neely had major damage. The pier broke off and it hit her house. So she had over $70,000 of damage. Our concern is if, again, when the next storm hits, we know it's going to, and more damage is done, is she going to be able to get machinery around the buildings of these homes to get the work done properly and safely. That's a big concern with her. Also, again, ideally, I believe the Markles want to go 2 feet and then a foot both ways. How is that going to affect, the safety of that, or a 2-story house where her house is a single story? How's that going to affect her home or mold or whatever? We don't, where they're all the way from 9th all the way past Matt's place, I'm sorry, I say Matt, like you guys know, I'm sorry, where the 2 empty vacant lots are, then the house to the west of that that's Matt's place. They're all single stories, so I don't know how they've affected each other, if there has been any. So there's a concern for that. But my concern as across the street is the public safety part of it, is where we're talking about moving in another foot, where we already know if you drive down East Beach, which, obviously I live there, there's construction going, there's trucks, all the time. And then when we get to peak season, the parking and number of rentals they may have and the stuff, you don't know how many cars people are going to bring in. I know there's only a certain amount they're allowed to have. So we have the limit parking, and that's kind of a concern on my part too. But then there's this other thing I talked with Kim Anderson here in town, the realtor, and she said there's a deed restriction on this property that does not affect all properties, but it is on this one. I was wondering how that affects everything also. Again, I'm not trying to, I'm just really upset that good people seemingly, why aren't the realtors have to be more open? And like I said, I think it was in 20, the realtor they had to state that it said in the write-up, like if you go to Zillow or whatever, the write-up was, this is a non-buildable at this time. But then when this went back up for sale, nothing was put like that. And again, we don't have the renourishment. I honestly know when the renourishment comes up, I'm sure Cam going to come and change those lines. I don't know that for a fact. I didn't go to school to do it, but it's, logic means that they're going to be able to move it back then. So do these buyers here just have to wait till that opens up? It seems right, but I think really that's all I've really wanted to state to you all. Just coming from the neighborhood and our concerns from there.
Mark, any cross-examination?
Just that I believe that, I think it's Brady said that as long as it's 5 feet.
Marco, I'm sorry, but I really do need it to be on the microphone. Thank you.
She finally fell asleep, so sorry you bored her.
That effect.
Thank you. Anyway, I just wanted to make sure that we are on the clear that as long as we have 5 feet on each side, which we will have more than that between structures, that any safety issues are alleviated because any vehicles needed can get through. And just want to make sure did that put you at ease at all? Sure. Okay.
Thank you. Any questions from the board? All right. Thank you, sir.
Thanks, everybody.
Anyone else want to speak at this variance hearing? Madam Clerk, let the minutes reflect no one has indicated they want to. Ms. Markle, since you have the burden of proof as the applicant and you are a lawyer, would you like to give some sort of summation or closing argument?
I really just want to say thank you for considering our application. I don't want to take much of your time, but just to reiterate quickly, I feel the 4 criteria are easily met with this unnecessary hardship that the lot cannot be built on, which the statute actually expressly says you don't have to prove that, but so we've gone above and beyond on that. It's unique, and this is the only lot that has this restrictive covenant and the more strict CAMA restrictions to comply with. No other lot has that. That this is not caused by us. It wasn't caused by the seller either. He may have been aware of it, we don't know, but he didn't cause it. This is caused by the combination of the new CAMA regulations and this restriction from 1968. And this furthers the spirit and intent of the law by putting property to its highest and best use by having another beachfront property that we can create memories and tax revenue for generations at. So it's the spirit and intent of the law, especially because we are absolutely all about protecting the beach and making sure that we are not building within that 60-foot setback from the first line of vegetation. So with that, I don't think I need to take any other questions, or?
If they have them, you may want to answer.
Okay.
Just one question. Maybe you've already said it, maybe I didn't understand it. But given the restricted covenants and the town code, it's not a buildable lot.
I'm sorry, can you repeat that?
It is not a buildable lot.
Correct.
Because
Without this variance, this is a
now, does
non-buildable lot.
that- Even though that's the case, are you obligated to close on the lot at this point in time?
No, we are not obligated.
So you're not at loss?
I mean, we put a lot of costs into this, so we will
I don't
be.
doubt that. I don't doubt that. But
So
I'm just saying.
this is not, yeah, we can walk away, but we will have lost all the extensive costs that have been put into this.
In your contract, you have contingency and due diligence monies tied up. Is that refundable?
I'd have to go back to the wording and check, so that'll be a challenge in the future if this is not an option.
You don't know. You haven't discussed that with the seller?
I've discussed it, but it does depend on how this hearing goes, and the wording is a little bit, I mean, it's a specific amendment that's been drafted, the second amendment, which I think was in the packet. I believe that we get our deposits back if the ruling is not in our favor, but anything can be litigated, and we certainly don't want to go down that route with our seller. We want to keep good relations as much as possible.
On page 33, it's 5,000 in due diligence. It's in the evidence.
What's the sales price?
I do not know.
671.
Oh, it's really just a fraction of the sale price.
You see that, I found the diligence.
Does the board have any other questions for the applicant? Thank you.
Thank you.
All right, we'll recess the evidentiary portion of this hearing, and the board can begin deliberations if during your deliberations you'd like to hear from staff or the applicant or Mr. McAvey. We can do that. That's why I suggest we recess the evidentiary portion as opposed to close it. As I indicated earlier, the applicant has the burden of proof. The 4 criteria is in your agenda packet, and you saw it on the screen earlier. And to issue a variance requires a 4/5 affirmative vote of the board. Be happy to answer any legal type questions you may have.
Does the board have any other questions for staff?
I do,
Which staff, the planner or the director?
our attorney,
Our counsel.
our counsel,
Uh-oh.
yes. So they referenced this investments 2 versus Auger. Are you familiar with that case?
That's the case law that they're talking about?
Yeah.
Vaguely, but I think they even acknowledge that that's not enough to extinguish the restrictive covenant as I read their application. I will say that there's some, well, does that answer your question?
Well,
For purposes of today, the evidence has been this covenant is on the property.
Yeah,
It's enforceable. There are people with standing that can seek to enforce it if it's violated. And I think we need to kind of stay in that lane for purposes of this
Okay.
hearing.
all right.
Well,
That answered
that-
my question.
Yeah, that begs the question then, if we make this unbuildable lot buildable, does the town have any exposure because of our actions?
I don't see how the town would have exposure. If that were the case, every variance would open up the town. But- And
Well,
I believe the applicant has acknowledged that the request, there's two variations of the request, either 4 feet, which I'm calling up front, landward side, or 2, 1 and 1. So we need, to if there's a motion to approve, or we need
does
to.
anybody put a pencil on that? Just, we're lacking 160 square feet. What would, that 1 foot on each side and 2 foot on the front,
1,008 square feet.
what would that calculate to?
1,008 square feet, so we need it by 8 feet total.
You're gonna get down to inches here?
Yeah,
9 inches on each side.
Yeah,
I think,
just keep it in nice round feet.
I think it's unfortunate that it's action by a different government agency that we are now having to remedy.
Yes.
But I do think that we are required to provide a remedy in this situation. Otherwise, we have, we, the town, by our restrictions, have rendered this lot unbuildable.
Well, the CAMA did that.
CAMA did that,
said
but
another
it is,
government
it is CAMA's, it is our regulations at this point that are preventing the house from being built.
Absolutely.
You know, and so my inclination would be to grant the variance, given that I believe that all 4 criteria have been met. And I think our discussion should be which of the 2 alternative variances would be most appropriate in this situation.
How do you feel? I agree
Hate to
with, I
go
agree with
into
Steve.
encroachments, but I agree. In this case, because CAMA did this, I mean, here's the thing. Those other buildings next to it, if they're more than 50%
Yeah,
damaged, they're not going to be able to be rebuilt the way this is laid out because of this restricted covenant. I'd really like to see that covenant go away. But-
or the line of vegetation is gonna change eventually. Now, it could
Yes.
change for the worse. You don't know.
Yeah,
But we're dealing with here and now.
yeah, so
That's-
I'm inclined to do the 2+1 on each side.
Mm-hmm.
I'll move that. 2+1
that.
variance granted.
What do you think?
I agree.
Okay,
That would be my inclination, 2+1.
all right. I agree with that, to keep from going forward towards the street.
Right. I think that would be, have the least visual effect.
All right, you want to put that into a form of motion?
Yeah, I would move that we grant the variance with a request with the stipulation that the variance granted be for 1-foot setback relief on each side and 2-foot setback relief on the front.
Street side.
Staff,
Street side.
where's Brady? The street side, we,
Asking for 13
in our
feet
code, we
anyway.
call it front yard setback.
Correct, yeah. The front yard setback is off of East Beach in this case.
Okay, so it'd be a 2-inch encroachment allowed from the front yard into the front yard setback and a 2-foot.
2 foot.
Motion to approve a variance allowing a 2-foot encroachment into the front yard setback and a 1-foot encroachment on each side yard setback.
Has Lisa got that?
Yes, sir.
I'll second the motion.
Second it.
First and second, all in favor? Passes unanimously.
Have fun with your new house.
If there's-
That's
There a
the best-
motion to close the hearing?
Yeah. That's the best behaved baby I think I've ever seen.
Oh, well, she's the 4th child, she's got
I haven't heard a peep.
she fell asleep,
If you need a second, you got it.
thank you, everybody.
We're done.
We're done. Oh,
We got a first and a second to close the,
yes.
Okay. All right, well, yeah, I'm going to agree at some point. We encountered the same situation when we built our house. If you look at the order, this is on the plan. And that, it would give them, as long as they checked out paneling, but it would have been the first floor porch. The paneling got posted, putting a camera.
Did we make a motion to adjourn?
Yes, we did.
I believe we thoroughly exhausted all angles of that.
yes,